Comsec, is there a quorum?
Your Honor, while we are finalizing the count of the members, it appears that there are more than 5 regular members present today, which is the minimum required to constitute a quorum to the committee, Your Honor.
There being a quorum, I now proceed to...
Okay, so good morning po. Ngayon po ay nakatutok tayo dyan sa may House of Representatives kung saan po ginaganap ang isang virtual public hearing, no, sa unang pagkakataon sa impeachment case laban kay Justice Mario Victor Leonen. At kakatapos lang po ng roll call at nagsasalita po ngayon si Chairman Vicente Ching Biloso, no, ng 3rd District of Leyte, na siya po ang namumuno sa hearing. Pakinggan po natin ang kanyang boses.
Accordance with the highest constitutional standard, public office is public trust. This is the first impeachment proceeding we have in the 18th Congress. The impeachment complaint was filed by Mr. Edwin Cordevilla, who describes himself in the complaint as the Secretary General of the Filipino League of Advocates for Good Governance, FLAG in short. The respondent to this complaint is Supreme Court Associate Justice Marvic MVF Leonen, and this impeachment complaint is accompanied by a resolution of endorsement signed by the Honorable Angelo Marcos Barba, representative of the 2nd District of Ilocos Norte. With the indulgence of our distinguished members, the Chair would like to open this meeting with a brief background of the impeachment powers of Congress before we proceed to the initial deliberation of the impeachment complaint. As I earlier mentioned, the Constitution gives the highest regard to accountability of public officers. This is readily apparent when an entire article is dedicated to the accountability of public officers. Section 1 of Article 11 states that public office is a public trust, unquote, that public officers and employees must at all times be accountable to the people, serve them with utmost responsibility, integrity, loyalty, and efficiency, act with patriotism and justice, and lead modest lives, unquote. These are the standards that all public officers must live by. Considering the highest public officials of the land are held to the highest standard, the Constitution provides for a special way of exacting their accountability, and that is through the extraordinary action of impeachment. Impeachment has been defined as a mechanism designed to check abuse of power and is described by the Supreme Court as the, quote, most formidable weapon in the arsenal of democracy, unquote. According to Justice Sagadi Cruz, impeachment is an extraordinary means of removal exercised by the legislature over a selected number of officials, the purpose being to ensure the highest care in their indictment and conviction, and the imposition of special penalties in case of a finding of guilt, taking into account the degree or nature of the offense committed and the high status of the wrongdoers. It is a process that is sui generis, or is a class by itself. Since impeachment not only involves legal, factual, and constitutional questions, it also has a political aspect owing largely to the fact that it is the duly elected representatives of the people, the members of the House of Representatives, and the senators who respectively were given the sole exclusive power to initiate and ultimately decide all cases of impeachment. Section 2, Article 11 of the Constitution defines who are impeachable officials, and they are the President, Vice President, members of the Supreme Court, members of the Constitutional Commission, and the Ombudsman. It further defines the grounds for which these officials may be removed from office, specifically culpable violation of the Constitution, treason, bribery, graft and corruption, other high crimes, and betrayal of public trust. Section 3 of Article 11 of the Constitution outlines the procedure for impeachment from the filing of a complaint by a member of the House of Representatives or by a Filipino citizen to the actions to be taken by the House of Representatives and again by the Senate, respectively initiating and trying the case for impeachment. First paragraph of Section 3 states that the House of Representatives shall have the exclusive power to initiate all cases of impeachment. The term initiate has been further defined in the case of Francisco versus House of Representatives, where the Supreme Court held that initiation of impeachment proceedings, quote, takes place by the act of filing and referral or endorsement of the impeachment complaint to the House Committee on Justice. So at this point, we can now say that an impeachment complaint has already been filed with us as it has been referred to this Committee on Justice. The second paragraph of Section 3 states the manner of filing of a complaint and the process to be followed by the House and the Committee in taking up such a complaint. For the information of everybody present today and the public watching us online, allow me to read the said paragraph in its entirety. Section 3, paragraph 2. A verified complaint for impeachment may be filed by any member of the House of Representatives or by any citizen upon a resolution of endorsement by any member thereof. It shall be included in the order of business within 10 session days and referred to the proper committee within 3 session days thereafter. The committee, after hearing and by a majority vote of all its members, shall submit its report to the House within 60 session days from such referral, together with the corresponding resolution. The resolution shall be calendared for consideration by the House within 10 session days from such thereof. The final paragraph, which is paragraph 8 of Section 3, states that Congress shall promulgate its rules on impeachment to effectively carry out the purposes of this section. Thus, the rules of procedure on impeachment proceedings of this 8th Congress was adopted by the House on June 5, 2020 and was published on June 26, 2020 in the Philippine Star and Manila Standard. Again, under our Constitution, an impeachment complaint may be filed by any citizen against any of the impeachable officers, provided that the complaint must be accompanied by a resolution of endorsement by any member of the House of Representatives. To repeat, the complaint received by this committee contains a resolution of endorsement by the Honorable Representative Barba, and we will call on him later to affirm his endorsement of said complaint. And after such affirmation, we shall proceed to determination of sufficiency in form, and thereafter sufficiency in substance as provided in our rules, depending on the outcome of our proceedings today. Pertinently, Rule 2, Section 2B of our impeachment rules mandates that the complaint of Mr. Cordevilla be verified. Section 3 of the same rules of procedure impeachment proceedings states that impeachment complaint is verified by an affidavit which says that the complainant has read the complaint, that the allegations therein are true and correct of his personal knowledge or based on authentic records, unquote. It more importantly provides that, quote, an impeachment complaint required to be verified which contains a verification based on information of belief or upon knowledge, information, belief, or lacks a proper verification shall be treated as an unsigned impeachment complaint. I repeat, a verification which does not comply with Section 3 of our impeachment rules shall be treated as an unsigned impeachment complaint.
Okay, so ililipat ko lang po no para meron tayong video sa nagaganap ngayon na hearing ng Committee on Justice diyan po sa House of Representatives no. Pupunta po tayo sa Facebook page ng ating Kongreso para po mapanood itong nagaganap ngayon na public hearing, no? At katulad po sa nabanggit ko na kanina, salita po ang nagsasalita po ngayon ay si Congressman Vicente Ching Veloso, no, ng 3rd District ng Leyte, na siya po ang chairman, no, ng House Justice Committee. At siya po ay retired na Court of Appeals Justice. So, ibig sabihin, talagang marunong ito, matalino ito pagdating po sa ating batas. Okay, panurin po natin at pakinggan.
Minorities shall be allowed to speak alternately. Now, due to the limitations of our online meeting and in accordance with our rules, the committee secretary shall call on each member present for their votes on any matter requiring a vote, and each member shall cast their vote verbally or may send a message to the committee secretary who shall verify the vote cast by such member. A while ago, Honorable Lawrence Pensor requested me to come up with an overview before we proceed to our determination of sufficiency or insufficiency of form. Involved pertinently is Rule 2 of our impeachment rules, particularly Section 2B, which says that a verified complaint filed by any citizen upon a resolution of endorsement by any member thereof must be present in that complaint. Number 2, Section 3, second paragraph, which says that an impeachment complaint is verified only by an affidavit complying with the following requirements: that the affiant must aware that he has read the complaint. Second, that all allegations therein are true and correct of his personal knowledge or based on authentic records. These two will be the bone of contention in our proceeding today. The third paragraph disallows allegation based on information and belief, allegation based on knowledge, information, and belief, and if that would be the case, the complaint will be treated as an signed impeachment complaint. Rule 3, Section 4, in the determination of sufficiency in form, if it is insufficient in form, measured by the standards I earlier mentioned, the complaint shall return to the section within 3 days. There is a second point that I would like to inject for the uh, appreciation of the members of the committee. Rule 3 does not mention dismissal of the complaint or the impeachment. It says we are to return the complaint to the section within 3 days. But Rule 7, Section 17 of our impeachment rule says the rules of court will apply to our impeachment proceedings supplementarily as far as they are practicable. And in this regard, let me point out that Rule 16, Section 1 of the Rules of Court provides that the motion to dismiss may be filed or is proper on grounds, among which is paragraph J, a condition precedent for the filing of the complaint has not been complied with. The second action, therefore, that the committee can take, instead of referring it to the Secretary General, is following Rule 7, Section 17 of our impeachment rules. A motion to dismiss is proper if the committee finds by proper vote that, among others, the condition precedent of filing a correct verification has not been complied with.
Okay, sa mga latecomers po, no? Sa mga latecomers ngayon po sa ating live stream, ito po ay live coverage natin, no? Sa nangyaring hearing dyan, virtual hearing dyan sa House of Representatives Justice Committee. At nakikita niyo po sa screen si Congressman Vicente Ching Veloso ng 3rd District of Leyte na siya ang chairman, no, ng komitiva. Si Congressman Veloso is a retired Court of Appeals Justice, kaya makakaasa po tayo na talagang titignan niya ang lahat na ito sa mata po ng isang experience, no? At napakahaba po yung kanyang pagpanungkulan sa orado, kaya talaga pong we can have the confidence na everything will go smoothly accordance with the law and the rules of procedure of the Senate. Balikan po natin si nandito po si Congressman Barba, no, nagpapaliwanag ng kanyang endorsement.
Virtually to formally endorse the verified impeachment complaint filed by my constituent Manong Edwin Cordevilla against Associate Justice Mario Victor F. Leonen. As we all know, impeachment is a constitutional process of removing the President, Vice President, members of the Supreme Court, members of the constitutional commissions, and the Ombudsman from office. It has a noble purpose of sparing the nation from the scourge of an undesirable public official who wields power in disregard of the constitutional order. An Associate Justice of the Supreme Court is one of these impeachable officers. In 2011, the House of Representatives initiated an impeachment complaint against a sitting Chief Justice, the late Chief Justice Renato Corona. He was found guilty of culpable violation of the Constitution and betrayal of public trust when he failed to disclose to the public his statements of assets, liabilities, and net worth, as required under Section 17, Article 21 of the 1987 Constitution on May 29, 2012. The dramatic turn of events and the subsequent judgment set a precedent. In the words of Senator Judge Franklin Drilon, the SALN requirement is not a mere formality, as it goes into the heart of a public official's moral fitness to hold public office. Those who dispense justice must conform with the highest standards of professional integrity and personal honesty. Impeachment is not just a political process. It is more than that. It's about accountability. It is about holding our public officers accountable, not for who they are, but what they do or fail to do. Their actions or the lack thereof matter. I'd like to quote a portion of the opening statement of the prosecution during the impeachment trial of the late Chief Justice Corona. As public servants, we took an oath to uphold the people's will at all times. All who hold positions in the government of our republic are accountable for their actions. For the power of the sovereign Filipino people is a power that is higher than the executive, the legislative, or even the judiciary. And therefore, no matter how high and mighty one's position may be, no one can ever be beyond public accountability. We as representatives of the people established the highest standard, not only for a Chief Justice, but for all justices of the Supreme Court. As Senator Judge Antonio Trillanes III perfectly said when he explained his guilty verdict, from now on, no one is untouchable. I want to believe this holds true to this day. Mr. Chairman, honorable members, maraming salamat po.
Uh,
Point of inquiry, Mr. Chair, if I may be allowed.
yes, Deputy Minority Leader Kimbo. Abel Monte, rather, Kit. Sorry.
Thank you very much, Mr. Chair. Good morning po sa lahat. I was just wondering, Mr. Chair, I was listening very intently to the rules as outlined by the Honorable Chair. And I noticed that my copies of the impeachment complaint doesn't have certified 2 copies of the annexes and the attachments. And may I just inquire of the committee secretary, Mr. Chair, if the originals were certified 2 copies, Mr. Chair. I think that is important as we go forward, Mr. Chair.
Comsec.
Yes, Your Honor. Thank you. The complaint as received by the committee, Your Honor, and as transmitted by the plenary is the same as were scanned and were transmitted to all the members present today. So what our members have in their possession are the same that copies we have in the committee, which are either only photocopies and do not contain certified 2 copies of the attached documents, Your Honor.
So, to be clear lang, Mr. Chair, pareho ang kopya, wala akong certified 2 copies ang attachment sa complaint. Para lang ako clear. Thank you very much, Mr. Chair. I just wanted that.
And in short, what you're saying, Honorable Minority Leader, is that the matter of sufficiency in form on the basis of authentic documents is no longer an issue. Is that correct?
Thank you very much for clarifying it very clearly. Thank you very much, Mr. Chair.
I am asking you.
Mr. Chair. Yes, Mr. Chair. Exactly.
Okay. Thank you. So maybe now proceed to the manifestations. Comsec, who is first on the line?
Your Honor, before the manifestations, our member, Honorable Fortune, wishes to make a manifestation.
Okay. Go ahead, Honorable Fortune.
Thank you, Mr. Chairman. Good morning, distinguished colleagues. Mr. Chairman, impeachment in the Philippines is meant by our Constitution to be an earnest, fair, and just constitutional process by which Congress, with its expressed exclusive power granted by the Constitution, may charge, try, and remove a serving government official only on the grounds enumerated in the Constitution. Under our Constitution, only the President, the Vice President, members of the Supreme Court, members of the Constitutional Commissions, and the Ombudsman may be removed by impeachment, and only on any of the grounds provided for under the Constitution, namely culpable violation of the Constitution, treason, bribery, graft and corruption, other high crimes, and betrayal of public trust. Offenses or acts not constituting those enumerated cannot be a ground for impeachment. In other words, Mr. Chairman, given the gravity of the offenses and the prominence and critical importance of the public offices or positions involved, impeachment should thus be a solemn, fair, and impartial process, whose proceedings and conclusion should serve not political, partisan, or personal ends, but essentially and only truth and justice. Members of Congress taking part in this process, Mr. Chairman, should ensure that it be not tainted with bias, prejudice, politics, conflict of interest, or impropriety. It is for these reasons, Mr. Chair, that I make this manifestation. The respondent in the case pending before us is, aside from being a member of the Supreme Court of the Philippines, also the chairman of the House of Representatives Electoral Tribunal, of which this representation is an active member. Not only do we sit in the same tribunal, Mr. Chairman, the impeachment complaint filed against the respondent also set forth as ground alleged deliberate and unjustified delays in the handling and disposition of cases in the said tribunal, of which, I reiterate, I am a current member. Mr. Chair, while I have consistently strived to maintain fairness and impartiality in my participation in all proceedings of the Committee on Justice, including the impeachment of former COMELEC Chair Andy Bautista and former Chief Justice Lourdes Sereno in the 17th Congress, my participation in the impeachment proceedings, now involving the chairman of the House of Representatives Electoral Tribunal, may be perceived to be tainted with bias and partiality. Mr. Chairman, to spare the committee from such possible perception, fairness and propriety dictate that I refrain from taking part in these proceedings. Inasmuch as I desire to actively participate and be of contribution to the committee in arriving at a respectable conclusion, I have resolved to take my hands off the matter. I hereby, Mr. Chairman, with a heavy heart, inhibit from this case. Thank you and good morning, Mr. Chair and distinguished colleagues.
Thank you. The chair also, for the record, acknowledges the receipt of a letter from the Honorable Stella Luz Kimbo, representative.
Okay, so narinig niyo po ang pahayag ni Congressman Fortun, no? Na dahil po siya ay kasapi ng House of Representatives Electoral Tribunal, kung saan nagsama-sama sila diyan ni Justice Marvic Leonen, no? Kung saan po si Justice Leonen ang chairman diyan, ay magpapaliban siya, no? He will refrain, hands off po siya, inhibit, no? Kita nyo, mabuti pa si Congressman Fortun dahil ayaw niyang daw nito, ayaw niyang malagyan ng kulay yung kanyang pagbahagi diyan sa impeachment complaint na baka papabor ito kay Justice Leonen. Kaya nag-inhibit. Ito po, katulad po ito yung hinihingi sana ni dating Senador Ferdinand Bongbong Marcos Jr. na mag-inhibit din sana si Justice Leonen dahil po dun sa siya yung ponente sa kaso ni BBM sa to unseat, no, or to declare as mali, no, o na resulta po ng dayaan yung pagkapanalo ni FBP Lenny Robredo, ay humingi sana po si BBM na mag-inhibit din, no, dahil nakikita po in the past, no, na may mga nabitawan na salita si Justice Fortun na may galit ito sa pamilya Marcos, pero hindi po nag-inhibit. Ito po ang ibig sabihin ng inhibition na hinihingi ni BBM sa kay Justice Leonen. Pero nakita nyo naman ay couple books po, no? Couple books itong si Justice Leonen ay talaga pong kapito ko, ayaw niya pong bitawan ang kanyang papel bilang ponente, no, sa kaso na electoral protest. Balik tayo sa hearing ng House of Representatives Justice Committee.
Other. Okay. Second list for manifestation. Or third, rather.
The Honorable Deputy Speaker, Rufus Rodriguez, Your Honor.
Okay, go ahead, Honorable Deputy Speaker Rufus Rodriguez.
Thank you, Mr. Chairman, and my distinguished colleagues in this hearing of the Committee on Justice on the complaint of Mr. Edwin Cordevilla, Associate of the Supreme Court, Marvic, Leonen. Mr. Chairman, our rules clearly states that the allegations of the complaint should be true and correct of his personal knowledge, the complainant, or based on authentic records, or based on authentic records. I have with me here the verification. I've been reading and rereading this complaint since it was referred to the committee. It says, I, Edwin M. Cordevilla, under oath state that I am the complainant in the above entitled verified complaint for impeachment, and I have caused the said complaint to be prepared and have read the contents thereof, and that the allegations therein are true and correct based on my personal knowledge. So this pertains to and would therefore be able to apply and being true to Section 3 of the statement that they should be true and correct of his personal knowledge. And the second one is quite not directly complying with the second requirement that it should be or based on authentic records, because after personal knowledge, the complainant states, and appreciation of the documents and other authentic records pertinent thereto. So that is the exact wording on the verification. Now, Mr. Chairman, as stated by confirmed by our committee secretary, none of this annexes to the complaint. Upon question by the Honorable Deputy Minority Leader, none of this, first, is authentic, and none of these are certified, either originals or certified true copies. Because an authentic document can either be original or certified to as true copies by the proper custodian of the document or the one issuing the document. So therefore, on this particular point, it is clear that it is not based on authentic record as required by our rules. Because we see, Mr. Chairman, as we read the complaint, that all the annexes are all Xerox copies and mainly coming from newspaper reports, online reports. Prefatory statement is based on Annexes 1 and 2 coming from ManilaTimes.net, 1 and 2, both ManilaTimes.net. Xerox copies of these documents. Then we also have, for general allegations from 3 to 12, again, all online news accounts, Xerox, and attached to the complaint. From Inquirer.net, number 3 to 12, ManilaTimes.net, all of them are therefore, allegations are therefore Xerox copies of newspaper accounts. Then we go now to the meat of the issue, which are the articles of impeachment. There are 3, Mr. Chairman. The first one is a failure to disclose at least 37 cases within 24 months as mandated by the Constitution. And we see here in their submission on these annexes, from annexes 1.1a up to 1.32-5, Mr. Chairman, all are also newspaper accounts except two, and these are Annex A and B, which are Supreme Court statistics on pending en banc judicial cases of respondent as of June 30, 2020. Again, as stated in one of the articles written by a columnist. There is no certified true copy, Mr. Chairman, of the Supreme Court report on the statistics on pending en banc judicial cases of respondent as of June 30, 2020. The other one, which is not a direct quote of newspaper accounts, is Annex B of Articles of Impeachment number 1, which is the list of cases assigned to Justice Mario Victor F. Leonen. Once again, this particular annex is also a reproduction of a listing of these cases in a newspaper account. Again, there is no authentic copy because there is no certification from the custodian of this list, which is the Supreme Court of the Philippines. In the second culpable violation of the Constitution allegation, delay in resolving cases before him as chairperson of the House of Representatives Electoral Tribunal. And we have from section 2.1-1 up to 2.14-3, three supporting documents for the culpable violation allegation on a delay in resolving cases in the HRET. Well, again, of the three, two comes from ManilaBulletin.com. The other one is Rappler.com. There is this the website of the Government Philippines HRET, the website of the HRET. Again, this came from the quotation in a comment in an article, which is likewise not authenticated by the House of Representatives Electoral Tribunal. So this is not also an authentic document. And then we go now to the third. Now this one is on betrayal of public trust. And the third article of impeachment, which is the betrayal of public trust, is failure to file his statement of assets, liabilities, and net worth, SALN, during his tenure at the University of the Philippines. And now once again, we have here also all are newspaper accounts or columns of commentaries, except that C, there is a communication operations of the Philippine Communications Operations Office. Again, there is no certified true copy of this. It's a Xerox copy. And then we have some statement of Justice Leonen, and then letters and so forth from the Supreme Court, and then bills of materials and so forth. Again, Mr. Chairman, no authentication, no certification from the proper custodian of these documents. So therefore, Mr. Chairman, this verified complaint on the second requirement of based on authentic records will not comply. However, Mr. Chairman, the word in our rule is or. So therefore, even if there is no authentic basic, that is not based on authentic records, it says or. So meaning the allegations are therein are true and correct of his personal knowledge. Now let us go into this, because on its face, we can see the complaint on whether it is really based on his true and correct, based on personal knowledge. That is the requirement, Mr. Chairman. This requirement is not hollow. It's not empty. This requires that on its face, it should be seen from the complaint itself that the allegations are really true and correct of the personal knowledge of the complainant. Mr. Chairman, a perusal of the complaint itself and the annexes would show that not one matter, not one annex is based on his personal knowledge. The records of the Supreme Court are in the Supreme Court. He's not a member of the Supreme Court, and neither can a member of the Supreme Court divulge under their confidentiality rule, because in the case of, for example, cases in the Supreme Court, the complaint violates the rules on disclosure and confidentiality of the Supreme Court. Its allegations, especially those relating to docket management and the case disposition issues, involve matters that are part of court deliberations and are thus confidential and protected by deliberative process privilege, Mr. Chairman. So therefore, all the allegations of this delay in the case in the Supreme Court and the docket, that is very, very internal to the Supreme Court. And then also, the complaint does not state any justification or authority or applicable waiver to invoke matters privileged to the Supreme Court, which matters cannot be submitted as true and correct because precisely it is a privilege to the Supreme Court. So therefore, we say that on its face, in spite the verification statement that they are true and correct based on personal knowledge, Mr. Chairman, there is therefore it is not sufficient informed. It is not sufficiently verified. And its verification is a travesty because it says my own personal knowledge, and then what is being attached and being cited are newspaper online reports of columnists who wrote or reporters who wrote about these issues. And therefore, Mr. Chairman, the first requirement that it is true and correct based on personal knowledge will not obtain in this complaint. And therefore, the complaint, Mr. Chairman, is undeniably purely hearsay. And the rules of evidence would say that hearsay evidence would not stand in any proceeding. No matter what the optical presence of a verification, as we can see, stating in the verification of the complaint, the reality is that hearsay cannot be verified. Hearsay, all these newspaper reports, all this downloading of certain websites, all of this cannot be verified as true and correct under the terms of the verification of oath of the complainant. Therefore, what we see here as a consequence of the nature of being deemed being hearsay, the complaint is beyond verifying because they are all hearsay. All of the documents are hearsay. All the attachment annexes are hearsay. And so therefore the complaint is beyond verifying and should be deemed unverified. When form of which the verification is appreciated as a deliberate facial feature of the complaint that serves a purpose of the highest order. The verification is written without regard to the purpose except to trivialize it, and the verification must be deemed not written. In view of the foregoing, Mr. Chairman, I would therefore maintain in this proceeding that the complaint is not sufficient in form. Thank you very much, Mr. Chairman.
Thank you for that, Comsec. Who is next on the line?
Next, Your Honor, is the Honorable Edsa Lagman, Your Honor.
Earlier, the Honorable Lagman wrote this representation as chair, but since he is on Zoom, I request that the Honorable Lagman amplifies his manifestation verbally.
Thank you, Mr. Chairman.
Thank you.
And honorable members of this committee. I would like to confirm that earlier in the morning, I submitted to the honorable chairman and the members of the committee through the committee secretary of the Committee on Justice a 3-page position on why the instant impeachment complaint against Justice Mario Victor F. Leonen, filed by Mr. Edwin M. Cordovilla, is not sufficient both in form and substance. Mr. Chairman, honorable members, Section 3 of the House Rules of Procedure in impeachment proceedings provides that the complainant's verification should be based on complainant's quote personal knowledge unquote or authentic records quote unquote. Complainant's verification stated that his allegations are based on his personal knowledge and authentic records. However, a reading of the complaint readily reveals complainant's lack of personal knowledge respecting the preferred grounds of culpable violation of the Constitution and betrayal of public trust against Justice Leonen. In lieu of his personal knowledge, complainant vicariously relied on newspaper accounts and columnist opinions which are not authentic records and are invariably hearsay. Complainant failed to attach to his complaint the authentic records or official certifications on Justice Leonen's purported failures to seasonably decide cases and file his salience for a number of years prior to his appointment as Associate Justice. Verily, complainant's lack of personal knowledge and dismal failure to attach the pertinent official certifications or authentic records indubitably make his complaint insufficient in form. Liberality as to form may overlook these defects, but it must be recalled that in previous proceedings before the Honorable Committee on Justice, the then chairman of this committee announced that henceforth liberality will no longer be accorded in assessing sufficiency in form. The reason is that form is not a mere matter of formality, but it is an essential initial prerequisite to be satisfied by the complainant. In fact, it is the least requirement which a complainant must complete.
Okay, so pare-pareho, no? Pare-pareho yung sinasabi ni Congressman Lagman at ni Rufus Rodriguez, no? Tinitira nila ngayon, inatake nila ngayon yung mga annexes, yung mga dokumento na isinama ni Edwin Cordovilla sa kanyang reklamo laban kay Justice Leonen na wala naman daw ni isa nito na merong nakatatak na certified true copy, no? At hindi ito na fulfill, no? Hindi na meet yung tinatawag na requirement that it must be authenticated, no? Ibig sabihin na galing talaga sa totoong kopya o kahit original man, no? Kung hindi man totoong kopya o original, ay kailangan po pag Xerox copy ito ay may istampa ito at napermahan na kung sino ang humahawak ng mga dokumento na yan. So ito palagi, no, ang ginagamit ng mga kumakalaban sa ganitong mga hakbang para na ma-derail, no, ma-discarrel ang reklamong ito. Pero titignan natin, no, kung sa totoo po may punto naman sila, pero panuorin po natin, no, at mapakinggan natin kung ano po ang magiging ruling ng chair, no, at kung ipapatuloy ito ang hearing ito. Kasi sa araw na ito, ang pinag-uusapan lamang is sufficiency in form and substance, no? Kaya doon sila pabalik-balik sa mga mismo sa reklamo at sa mga dokumento, no, mga papeles na naka-attach, no, nakakasama doon, no, bilang mga patunay. No? Balik tayo kay Congressman Lagman. And by the way, kung sino pa po dyan ang hindi pa po nakapag-thumbs up, we have 236 live audience. Kung sino pa po dyan ang hindi nakapag-thumbs up, kumari po ay mag-thumbs up kayo para po na lalong dadami po yung manonood sa live stream nito na nakakonect po tayo sa pamagitan ng Facebook page ng House of Representatives. Live po ito, no? Live po ito. Talagang tawag ito real time, no? Real time po ang takbo ng pangyayari. Kaya medyo mahaba ito, no? Okay, balikan natin si Congressman Lagman.
Constitute an impeachable offense. Justice Leonen allegedly failed to submit his Allen according to the complaint for the years 1989 to 2003 and 2008 to 2009. Granting again that this is true, it cannot be a ground for impeachment for the following reasons. One, the alleged failure happened before Justice Leonen was appointed Associate Justice in 2012. An impeachable incumbent official should only be impeached for offenses committed during his incumbency. This would foreclose malevolent searches for bygone skeletons in distant closets. Moreover, Justice Leonen's qualifications and compliance with mandatory requirements have been vetted by the judicial.
Okay, medyo sigit tayo, no? Kasi may sinabi si Congressman Lagman na dapat daw hindi na maaring gamitin pa yung pagkakasala. Parang inaamin niya na meron nga pagkakasala si Justice Leonen na nabigo siya sa pag-file ng kanyang Statement of Assets, Liabilities and Net Worth noong nakaraan pa, no, na habang siya ay nagtuturo pa sa University of the Philippines. So balit, lilinawin po natin, ito pong argument ni Congressman Lagman na hindi na maring balikan pa. Kung ano man yung mga kalansay, no, yung mga skeletons in the closet, sabi niya na maaring hukayin, hindi po yan katanggap-tanggap. Dahil doon nga po sa co-warranto laban kay Maria Lourdes Sereno, kung matandaan ninyo, yung pagtanggal sa kanya ay nakabase rin, no? Pinagbatayan doon ay yung pagkabigo ni Maria Lourdes Sereno na mag-file ng kanyang salin habang siya po ay nagtuturo din sa University of the Philippines, di ba? So, ibig sabihin, if we apply itong sinasabi ni Congressman Lagman, na kalimutan na natin yun. Kung nagkasala man siya dati, huwag nating kalkalin yun. Ay, hindi po maaari, Mr. Congressman. Dahil nagsalita na dyan, tungkol dyan ang Supreme Court doon po sa co-warranto case laban kay Sereno. At yun nga po, yun po ang naging dahilan na natanggal si Sereno. Balikan natin si Congressman Lagman.
I recommend that the impeachment complaint against Justice Leonen be dismissed for being insufficient in form as well as in substance. Thank you, Mr. Chair.
Okay, so yun po, no, ang pagkatapos po ng napakahabang paliwanag ni Congressman Lagman ay sumusuporta siya, sang-ayon siya doon sa panawagan na ni Deputy Speaker Rufus Rodriguez na dapat po i-dismiss ang kasong ito. Balik po tayo sa hearing at by the way, yung hindi pa po nakapag-thumbs up dyan, kumari po mag-thumbs up na ngayon, ay nakikita niyo po, tumataas po yung bilang ng ating live audience. Ibig sabihin na dumarami po yung mga nakakapansin, no, na meron tayong ganitong live coverage sa nangyayari dyan sa ating Kongreso. So, again, please click on the thumbs up sign. Balik tayo sa hearing.
All of these issues will definitely define the future or the political landscape of this country for few years to come. That's why today, as we face the gravest issue of impeachment vis-a-vis the pandemic issues that we have right now, I encourage everyone, every House member, to have the highest standards of discernment, to observe the highest standards of discernment in these cases. As we all know, impeachment cases, of all the cases that we have right now in the country, are the most celebrated ones. And celebrated as they are because these involve extreme cases of abuse of power, the extreme culpable breach of the Constitution, and these grounds have been lucidly stressed upon by the highest court in the cases of TS Bank versus Senate Impeachment Court, decided last February 9 of 2012. So with Gonzalez versus Office of the President, decided on January 28 in 2014, that considering the highest standards of discernment are being required because they deal with more than even heinous crimes, because it involves probably betrayal of public trust, then therefore we should deliberate on these issues with very much caution. But vis-a-vis about these issues that we have right now, we have also to consider the rules of procedure that we have right now. Number one, naalala ko po nung ako ay nag-aaral pa ng Bachelor of Laws, ako ay nagtatrabaho sa Supreme Court. Maliwanag ang sabi ng mga maestrado sa Korte Suprema na kaya sila naglalagay ng mga parameters o mga rules basically to avoid frivolous cases, to avoid delays, to avoid trivial issues that are even being elevated up to the Supreme Court. And in the same way, we have also cases and rules to be observed in the House of Representatives, particularly the rules of impeachment. It's very explicit and very categorical under Section 3, Paragraph 3 of the impeachment rules. It is clearly provided therein that the complainant in filing an impeachment complaint must be based on authentic records. Or if not, it should be out of his own personal knowledge. Now, browsing on the allegations of the complaint, I would like to understand, of course, the allegations of the complainant, as well as the manifestation of our good colleague from Locos. But seeing very clearly the allegations of the complaint or the impeachment complaint against Justice Leonen of the Supreme Court of the Philippines, the basic issues herein are actually not based on authentic records, because as clearly provided for and under the manifestation of our COMSEC, there are no authentic records on this matter. And more importantly and more significantly, I would like to stress upon this committee, Mr. Chair, that particularly the allegations as to the failure to dispose of the cases, as mentioned and alleged in the complaint, as well as the delay in the HRET cases, plus the non-filing of silence, are all based on article reports. I was part of the impeachment committees way back in the 16th Congress, 17th Congress, and now of the 18th Congress. And I would like to be reminded of those clear parameters set forth by the previous committees. And there's no reason to treat this case very differently. As the allegations are not based on authentic records, and as the allegations are not based on personal knowledge, but based on article reports based on Manila Times, it behooves actually the committee to deal this with the highest standards of ruling, that in this event, we should have no recourse but to treat this impeachment complaint as unsigned pleading. There being such, or being the case, this impeachment complaint, sad to state, is a mere scrap of paper. And considering that we have so many problems or pressing problems that we have right now, I think the better way to deal with this is to dismiss this impeachment complaint based on insufficiency as to form, based on Rule 3, Section 3, Paragraph.
Okay, so this will be the third, no? Pangatlo na ito si Deputy Speaker Doyle Diacion ng Occidental Mindoro. Mindoro yata ito si Diacion, no? So, sandali, no? Si Diacion is from Oriental Mindoro First District, no? Oriental Mindoro. So, ganun din po, no? Na yung sufficiency in form and substance, no, ay napakalungkot nga po, no, kung totoo nga po na nakaligtaan ito na i-verify o ipasiguro ng complainant, no, at ni Attorney Larry Gadon na baka po sa technicality, because alam na alam po natin na totoo naman po itong lahat na ito, no, especially on the filing of the non-filing of the statement of assets, liabilities, and net worth. Pero tingnan natin, no? Pero at least mabuti ito na napapanood ito ng taong bayan. Maraming nakakaalam po kung ano po ang magiging hakbang ng House Justice Committee dito. Si Minority Leader Kimbo, no? Ito ngayon.
Majority Leader, an eminent legal scholar, like the chairman himself,
Belmonte, no?
The then complainant.
Deputy Minority Leader Kit Belmonte, no? Kit Belmonte.
Knowledge of what he signed as a verified complaint. He was probably and possibly subject to perjury and even a probable ethics case because he was a member of the House, Mr. Chairman. My point of inquiry lang po is again, hindi po malinaw yung nakuha kong kopya, Mr. Chairman. Verified po ba or may signed verified complaint and subscribed and sworn to ng complainant, si Mr. Cordevilla, ang kanyang impeachment complaint? And kanino po to nakapirma? Ang records ko po ay sa mismong Secretary General ng House po siya nag-verify. And as such, pwede pong isang frivolous complaint na nag-verify siyang, nagsabi po siyang personal knowledge po niya, hindi po ba siya subject sa contempt proceedings din dito sa House dahil sa House po siya nag-verify na nagsabi po siyang...
Your Honor, we will treat that on other matters. Unahin mo lang natin itong point at issue.
Thank you, Mr. Chair.
Mr. Chairman.
Yes, Your Honor.
Mr. Chairman, I made a manifestation to give my manifestation also, if ever, and I'm ready to second the motion of Deputy Speaker Leonen, but may I be allowed to make a manifestation, Mr. Chairman?
Comsec, how many members do you still have after Honorable Abante?
Your Honor, the list is as follows. First is the Honorable Deputy Speaker, Bienvenido Abante, then Deputy Minority Leader Carlos Larate, and then Deputy Speaker Pablo John Garcia. Your Honor.
So we will be acting on that motion after all those who manifested the desire to speak on this issue must have said their piece. So may we now go to sino ba?
Deputy Speaker Abante, Your Honor.
Okay, Honorable Deputy Speaker Abante.
Thank you, Mr. Chairman. I am not a lawyer, but I'm a very observant member of the House. And I'd like to make this observation, Mr. Chairman. The gravity of an impeachment complaint cannot be discounted. You can talk to any ordinary citizen in the street who do not even know the laws of impeachment. And he will tell you that any impeachment complaint is very serious and grave. Henceforth, anyone who files an impeachment complaint should not be done just because he does not like the person or he has a grudge to grind. How grave is an impeachment complaint, Mr. Chairman? Looking at the impeachable offenses like culpable violation of the Constitution, which means a deliberate and wrongful breach of the Constitution. But it also says, and I quote, violation of the Constitution made unintentionally, in good faith, and mere mistakes in the proper construction of the Constitution do not constitute an impeachable offense. We talk about betrayal of public trust, Mr. Chair, betrayal of public interest, inexcusable negligence of duty, tyrannical abuse of power, breach of official duty by malfeasance or misfeasance, cronyism, favoritism, etc., to the prejudice of public interest, and which tend to bring the office into disrepute. That's how grave any impeachment complaint is, Mr. Chair, as I observe. Citing the manifestation of Deputy Speaker Rufus Rodriguez, who is a very good lawyer, and even Congressman Lagman, like kababayan, questioning the substance of the complaint to be true and correct, and that of personal knowledge being taunted about as hearsay. The complainant is making a mockery of the law, and that this impeachment proceeding is an exercise in futility when we have more important things to do and bills to tackle. May I just, Mr. Chair, one by one, speak on the complaint itself. First of all, the complaint seems to suggest that Justice Leonen is anti-Duterte because he was appointed by former President Aquino. Are we supposed to impeach a justice of the Supreme Court because of his political beliefs or his affiliations, or who appointed him? Is that what the Constitution states? Number two, in the complaint, there is also a charge that Justice Leonen should be impeached for failing to decide around 36 cases within the 24-month period. Seriously, is this a ground for impeachment under the Constitution?
Okay, so sisingit na naman ako muli, no? Kasi binabalik-balik nila na itong pagkabigo daw na mag-file ng SALN ay hindi daw dapat ito gamitin bilang batayan or ground para po sa pagpaalis ng isang impeachable official. Eh, parang pinapaikot-ikot ang nila ito. At kinakalimutan nila na yung unang impeachment po, doon po kay Chief Justice Renato Corona, ay base din po sa impeachment. No? At yung co-warranto, yung kasi may impeachment si Sereno pero hindi lang natuloy, no? Dahil nauna yung co-warranto. But in a co-warranto, again, the Supreme Court reiterated na napakabigat po ito na katungkulan ng isang public official. Lalo na po pag ang official na yan ay nakaupo sa Korte Suprema na sinusunod utos po ito ng batas. Kaya hindi ko maintindihan itong mga congressman na ito na parang minamaliit nila. They're trying to water down, no? Yung parang pinapalasaw nila yung bigat ng kasalanan ito na yung pagkabigo ng pag-file ng SALN, no? So anyway, wala po tayong magawa dito sa kanila kasi talagang, kumbaga, lahat sila ay nagtutulong-tulungan na talagang kinukuyog nila ngayon, no, itong impeachment complaint na para masira, no, masira itong inihain laban kay tawag dito, laban kay Leonel, no, ay napakabigat po because it touches on the integrity, yung pagkatao mismo, yung kalinisan ng budhi, no, ng pangalan ng isang tao, na hindi po dapat na ibinabaliwala ito ang issue sa SALN. Okay, nandito na yung paborito natin na makaliwa, no, si Congressman Carlos Arate ng Bayan Muna.
I fully agree with the chair earlier when he said that an impeachment complaint should be treated as an extraordinary means to make our officials accountable. And thus, we have to use this with utmost care. And I certainly agree, Mr. Chair and Lord, the masterful and surgical dissection of our esteemed colleagues like Deputy Speaker Rufus Rodriguez and Representative Edsel Lagman, our legal luminaries in this committee and in this House, as they analyze the complaint both as to form and even as to substance. The 201-page
by the way, kung hindi pa kayo nakapag-thumbs up dyan, no, please do click on the thumbs up sign dyan para po na lalong dumami yung nanonood. Balikan natin si Sarate.
Further peruse the complaint, even as to substance, it also failed to comply with our requirements. Tama po yung sinabi ng ating mga kasamahan, Mr. Chair. Kung babalikan lang natin, yung rules ng ating verification talagang wala na ito, hindi napapasa. But, you know, I also read carefully this complaint and even the verification several times. And I observed that the complainant made some legal maneuvers. Not only that, he said that this is based on his personal knowledge, which we already said it is not. He conjoined this with saying that personal knowledge and appreciation of, if I may quote directly, Mr. Chair, appreciation of the documents and other authentic records pertinent thereto. So lumalabas po, Mr. Chair, no, he made to probably cover up with the lack of personal knowledge, he made reference and incorporated his appreciation of the authentic records. And it even that, I think, legal maneuver, that legal contortion, that language acrobatics even made his verification worse. So, Mr. Chair, it cannot hide or mask the bare fact that, again, this complaint, as filed by the complainant and as endorsed by our colleague, suffered fatally as to form and even as to substance. Lahat po ito ay based sa hearsay documents, based only on newspaper clippings. Kung sa layman pa po, ito po ay chismis lamang. And we cannot rely on chismis, on hearsay, to impeach our high officials. The lack of knowledge of the complainant is apparent. And now he wants to use this committee, this House, to his foray into fishing expedition. Gagawin tayong fishing net to possibly justify the allegations he made in the complaint. Mr. Chair, at a time like this, when Congress should focus on more important matters like pandemic responses, pandemic interventions, when our people are still suffering from the grave crisis aggravated by this pandemic, more than 1 million people of our kababayans are already afflicted by this COVID-19. More than 20,000 were died of this COVID-19 disease. No? So we should focus our energies as a House, as a committee, on these pressing problems. Thus, I agree with our colleagues that at the first instance, and this is the first instance, we should not allow Congress to be weaponized if I may say, once again, for the sake of some vested interest at the expense of the independence of the other branches of our government, especially the judiciary, which have been subjected to attacks in these past years. And certainly, if we will stop these attacks now, then mahihinto din natin, mapipigilan natin yung chilling effects that is now reverberating in the other agencies and the other branches of our government. So, for all this, Mr. Chair, I fully agree and I support and I second the motion earlier made by our Deputy Speaker that this complaint should be dismissed. It should be dismissed.
Ginagamit nila yung patakaran, yung mga batas natin para po na makaiwas sila sa pananagutan. Because how can we now enforce accountability pagdating po lalo na dito sa SALN na napakahirap po. Nako, kung alam niyo lang, ngayon nga si Ombudsman Samuel Martires ay gusto niya dapat court order pa bago ka makakuha ng copy ng SALN. Saan po patungo? Because the Constitution says that public office is a public trust. So paano natin mapapanagot? At ang SALN nga po ay utos ng ating saligang batas na kailangan i-file ito ng lahat na opisyal, mataas man o mababa, opisyal at empleyado, para po matingnan kung sila ba ay sinasamantala nila yung kanilang katungkulan upang makaangkin ng malalaking yaman. No? They are protecting themselves. Yan po ang nangyayari dito. At nakakalungkot po na diyan mismo sa Congress ay sila po yung number one po na mga nagpapasiguro na hindi po mangyayari at mahirap po ipatupad itong panawagan ng saligang batas that public office is a public trust. Okay, balik tayo.
To act in a case or judgments on a justice's actions, especially in a deliberative body, would inescapably border on conjecture and speculation on whether we agree with the decision or action or failure to act or not. Secondly, and more importantly, impeaching a justice on the basis of his actions and inaction on cases before him would amount to a review by this political branch of the decisions of the judicial branch. This certainly was not the intent of the framers of the Constitution, and most certainly was the reason why impeachment cases are limited to culpable violation of the Constitution, treason, bribery, graft and corruption, other high crimes, or betrayal of public trust. In my opinion, the ground for impeachment should be extraneous to a justice's official decision, opinion, or disposition of a matter before him. On the second alleged offense, I must state that even if we were to assume that these were true, they were committed way before respondent assumed the office for which he is being impeached now, that is, as Associate Justice of the Supreme Court. It is my view that impeachment should be limited to offenses committed.
Okay, so ito po, no, si Deputy Speaker Henry John Garcia ng Cebu, na ganoon po sinasabi niya ngayon na huwag na pong pakialaman yung mga, kung may kasalanan man, may pagkabigo si Leonen na hindi siya nakapag-file noong wala pa siya sa Supreme Court, ay huwag na pong galawin. Again, ay katulad po sa nabanggit ko sa kaso ni Sereno, ay hindi na po maaaring gamitin na dahilan niya. No? Pangalawa, sinasabi niya na huwag natin pakialaman kung mabagal si Leonen sa kanyang hawak ng mga kaso. Kasi sabi niya, parang pinapakialaman natin yung trabaho ng equal branch, no? Co-equal branch, na sabi niya, huwag tayo manghimasok doon. Ito po, I'm sorry to say, Deputy Speaker Garcia, this is the very essence of the principle of checks and balance. Na ang bawat isa po ay maaaring bantayan at i-correct o ituwid ang pagkakamali, at kung kailangan po na parusahan, katulad po sa impeachment, ay parusahan, because who will check on the judiciary but through impeachment, no? So hindi mo po maaaring sabihin na dahil trabaho yon ni Leonen yung pinapakialaman, ay hindi po yan mabebenta, no? It cannot be valid because it's precisely the principle, no? The principle of checks and balance, no? At ito po ang hindi niya po nasusunod, yung 24-month rule, kasi may patakaran po ang Korte Suprema na ang bawat kasapi nito ay binibigyan lamang ng 24 na buwan mula po nang matanggap yung kaso na completed na po, na makagawa ito ng desisyon. Kasi it boils down also to the principle that justice delayed is justice denied. Ay naku, talaga pong nakakalungkot, no, na nakikita natin ng ganitong mga pag-iisip, no? Yung attitude, yung mga paniniwala ng mga congressmen, katulad din dyan sa Senado, hindi po nila talaga papayagan na mapapanagot ang mga katulad nila. Pag ganito po tayo, anong mangyayari? We are not a democracy, no? We are not a democracy. I can understand the rules, no? Pero dapat po bigyan ng leeway yan, kasi maaari naman pong ipasumpi na yan, no? Kung nandiyan po may mga kahit na Xerox copy yan, ay may pagbabatayan, no? Hindi po na inimbento niya lang na ginagawa niya, pinulot niya sa hangin yung sinasabi niya dyan. At ito po ay public knowledge, no? Kaya dapat po, kung hindi nga man po original, ay pwede pong isumpi na yan, no? Ang mga dokumentong yan, para po na mapatunayan kung meron nga, no? Kung meron nga sapat na ebidensya. Balik tayo kay Chairman Vicente Ching Veloso.
Point 3 reads, records from the Supreme Court reveal that as of 30 June 2020, respondent had 37 quote aging unquote cases. A copy of the Supreme Court report is attached here to as Annex A. But a quick look of it, as earlier clarified by the committee secretary, hindi po ito authentic copy. It cannot therefore be accepted by this committee as an allegation in support of the first ground. Also, 1.5, from paragraphs 1.5 up to 1.32, that is from pages 15 to page 24 of the complaint, all these allegations are not based on personal knowledge, much less supported by authentic pertinent records. Ground number 1 in the impeachment complaint must therefore fall. Let's go to ground number 2. The complainant alleges a second ground for impeachment, that the respondent committed culpable violation of the Constitution for arbitrarily delaying the resolution of cases pending before him as chairperson of the House of Representatives Electoral Tribunal. It's read for brevity. 2.1 alleges, and that is in page 25. Paragraph 2.1 alleges that in October 2019, respondent was appointed as the chairperson of the HRET when he headed the tribunal there, where
Sa ngayon po ay mukhang nagagawa na si Chairman Vicente Ching Biloso ng kanyang mga napuna din, no? At parang sinusuportahan niya yung mga nagsalita na earlier, no, na kailangan i-dismiss dahil hindi authentic, no? Eh nakakalungkot po na ganito po ang patutunguhan ng reklamong ito na talaga pong binantayan ang buong sambayanan, no? Na nakikita po natin na may basihan naman itong mga isinampa na kaso ni Edwin Cordevilla, no? Na kailangan po patalsikin sa pwesto itong si Justice Leonen. Nakakalungkot po, no? At mukhang sa takbo po ngayon ng mga usapan diyan ay mukhang hindi po papalusutin ito. Ay naku, malaki pa naman ang tiwala natin, no? Sa ating House Justice Committee na dapat po mabigyan sana ng pagkakataon. But kung wala po, wala, no? Wala po tayong magagawa, no? Talagang kailangan natin tanggapin na ganito po talaga ang sistema sa ating bansa, that we have congressmen and senators na sila po ang gumagawa ng mga rules that make it very hard, no? Kung ordinaryong Pilipino ka po, ay lalong hindi ka po makakapagreklamo tungkol dito sa mga katiwalian na mga impeachable officials kasi yung kinakailangan nila ay tawag dito, napakahirap po makakuha yan, no? At hinihigpitan pa ngayon yung katulad sa kung paano makakuha ng tinatawag na statement of assets, liabilities, and net worth. Iba po sa ibang bansa, katulad sa Amerika, sa mga ganitong pangyayari po, ay ang Congress mismo ay naghahanap, no? Naghahanap ng independent investigator na tinatawag. Kung matanda ninyo yung dati kay former President Bill Clinton nung impeach siya, no? If you remember yung kay Monica Lewinsky, yung babae na nag-iskandalo dahil nakikipag-sex daw sa kanya si President Bill Clinton sa loob mismo ng White House, meron po silang itinalaga, no? Ang American House of Representatives, US House of Representatives ay nagtalaga ng special independent prosecutor, na siya po ay binigyan ng kapangyarihan na magsubpina ng mga documents para po matipon, no, makagather, no, makagather ng mga kailangan na ebidensya na mapatunayan kung merong ang pagkasala si Pangulong Bill Clinton, no. Pero pagkatapos po ng mahabang panahon ay hindi pa rin po nagtagumpay yung impeachment. Although umakyat po yun sa Senado, at kumpleto po lang pagdating po sa Senado, alam nyo man po, yung impeachment talaga is a political decision. Kaya kahit na malakas yung ebidensya pagdating sa Senado na ay maraming mga tao dito, mga kakampi, no, ang ini-impeach na presidente, ay hindi pa rin po makakalusot. And we saw that, no, doon po sa kay President Donald Trump, no, na yun po, walang nangyari doon sa impeachment laban sa kanya, no, dahil nga divided yung US Senate, no, at maraming mga tao dito, mga kakampi doon si President Trump, kaya hindi po nagtagumpay yung butuhan doon pagdating sa Senate, no. Pero ganun po talaga ang ginagawa ng sa Amerika at sa ibang bansa. Meron po silang independent investigator o independent prosecutor na hindi po ito maaring influensyahan ng kahit kanino, ng kahit sino, no. Para po talaga yung mga katulad na ito na ebidensya ay mahahanap niya at ito po ay gagamitin sa pag-file ng kaso. Balikan po natin si Chairman Biloso.
17 of our impeachment rules mandating that the rules of court shall, as far as practicable, apply impeachment proceedings before the House, quote unquote, and considering moreover that Rule 16, Section 1 of the same supplementary rules of court provides that a motion to dismiss can be made on any of the following grounds, particularly paragraph J, that a condition precedent for the filing of the claim or in this case of a complaint, has not been complied with, the chair opines that what we have in sum is an unsigned, quote, unsigned impeachment complaint that is provided for in section 3, third paragraph, due to the failure of the complainant to verify his complaint on the basis of allegations therein, quote, allegations therein that are true and correct, of his personal knowledge or based on authentic records, unquote. Ulitin ko po, the verification failed to satisfy the requirement that the allegations of complainant must be based on his personal knowledge or must be based on authentic records. The chair would like, as I earlier point out, to emphasize that while under section 3, third paragraph, rule 2, upon a finding of insufficiency in form, we are to refer the complaint back to the Secretary General. There is, however, an alternative, and I cited Rule 16, Section 1, Paragraph J, that we can dismiss this complaint outright due to the failure of complainant to comply with a condition precedent for the filing of this complaint. The complaint, ulitin ko po, tantamounts to an unsigned impeachment complaint, as so stated in Section 3, third paragraph of our impeachment rules. So, the chair now is open to any motion. Alin ang gagawin natin? Should we throw this back to the SecGen or should we dismiss this outright? Any motion?
I move, Mr. Chair, to dismiss outright the complaint.
Mr. Chair?
Yes, Your Honor.
Yeah, the incident pending before this committee is a pending motion to dismiss the complaint based on Section 3, Paragraph 3 of the impeachment rules. The impeachment complaint is insufficient as a substance, and there being a motion that is pending, and so move. May I therefore request, Mr. Chair, your kind intercession to make the necessary ruling. Thank you, Mr. Chair.
Comsec, the first motion is should be to outrightly dismiss this on the basis of Section 1, Rule 16 of the Rules of Court that has been adopted as part of our rules pursuant to Section 17, Rule 7 of our impeachment rules. If that is carried, then we will no longer return this back to the SecGen, but rather we will be preparing and submitting a committee report on the matter.
I so move, Mr. Chairman.
So,
I second.
Second.
Second, Mr. Chair.
Second.
Comsec, will you take a vote on that?
Yes. Yes, Your Honor. Thank you. So the pending motion, Your Honor, is the motion to dismiss the impeachment complaint filed by Mr. Edwin Cordevilla against Supreme Court Associate Justice Marvic Leonenin. A vote of yes is a vote to dismiss the complaint, while a vote of no is a vote to sustain the complaint or not to dismiss the complaint. We start with the regular members of the Committee on Justice, the Honorable Vice Chairperson, Cyril Beng Abueg Zaldivar.
Mr. Chair, my vote is yes to dismiss the complaint.
Thank you, Your Honor. The Honorable Vice Chairperson, Nayala Rose Bainto Aguinaldo.
Mr. Chair, my vote is yes to dismiss the complaint.
Thank you, Your Honor. The Honorable Vice Chair, Jonathan Keith Flores. proceed with the Honorable Vice Chair, Juan Fidel Felipe Nograles. We proceed with the Honorable Vice Chair, Alfredo Garbin Jr. The Honorable Vice Chair, Ramon Nolasco Jr. The Honorable Representatives Ruel Peter Gonzaga, Honorable Representative Doy Liachon,
I vote to dismiss the complaint.
Honorable Cheryl De Loso Montalia, Honorable Tyrone Agabas, Honorable Peter John Calderon, Honorable Dalia Loyola, Honorable Manuel Luis Lopez, Honorable Corazon Nunez Malanyaon, Honorable Joseph Ramirez Sato,
I vote yes to dismiss.
Honorable Aleta Suarez, Honorable Hector Sanchez, Honorable Edsel Lagman,
Mr. Chairman, I vote yes to dismiss the impeachment complaint against Justice Leonenin.
Okay, so wala na po, no? Sa masamang palad, no, ay wala nang pag-asa sa ganitong takbo. Kaya ito na lang po ang masasabi natin na siguro may isang paraan pa. At may nabasa akong ulat na si Solicitor General Jose Calida ay nakahingi po ng tao dito ng certified copies mula po sa University of the Philippines na yun nga po, may mga salensya na sa ilang taon, 15 taon na hindi po na-file. So siguro mas mabuti kasi dito po sa impeachment talaga pong nagagamit po ang kapangyarihan ng politika, no? At hindi po nabibigyan ng daan yung hinanaing ng taong bayan. At again, it goes back, no? Lahat po ito ay bumabalik po tayo doon sa 1987 Constitution that public office is a public trust. Katulad po sa narinig natin ngayong umaga, ay halos lahat po na nagsalita ay sinasabi na, huwag kayong makialam. No? Kung ganyan si Leonen, wala na tayong magawa dyan. No? Huwag natin siyang pakialaman at huwag natin ipalabas na dahil kritiko siya ni Pangulong Duterte, ay kailangan tanggalin siya. It is a very sad testimony to our democracy, sa totoo lang. Kaya po ako ay frustrated sa tinatawag na demokrasya sa ating bansa. We are not a true democracy. Marami pa pong pagkukulang sa ating institution sa gobyerno na nagagamit ito, lalo na po yung tinatawag na rule of law, na dito po nagtatago, dito po nag-cover, dito kumukubli ang mga tiwali sa ating lipunan. Ang oligarko, ang mga traditional politicians, ang haba ng nagsalita kanina, no? Kaya siguro tama po yung mga ibang comment dito na nagsasabi na, well, ang paraan dito is ipagpatuloy natin, no? They should now make us angry, no? Kailangan po na magkaroon tayo ng sapat na galit para po marinig ng buong bansa, lalo na po itong mga taong ito na sinisikap na palagi na hindi po mangyayari yung accountability. Pananagutan po ang pinag-usapan dito under our Constitution. Parang niloloko lang natin ang sarili natin, no? We have the Constitution, we have laws, no? May SALN, may requirement, but ang sabi nila sa kamay lang po ng ilang tao at makakasabi sila. Wala kayo. Wala kami ang nasa kapangyarihan, no? We are in power. Bahala kayo sa buhay niyo. Buhay pa naman kayo. Di ba? Yan ang sinasabi ng dating Pangulong Benigno Simeon C. Aquino III, no, nung panahon niya, katulad po diyan sa tawag dito sa Senado, no, katulad po ng yung disbursement acceleration program, wala na. Tinambakan, inilibing na ng napakalalim at hindi na narinig, no? So paano po natin masasabi that there is rule of law, no? Na marami pong mga kasalanan na mas mabigat 100 times kaysa ordinaryong magnanakaw, 1,000 times kaysa ordinaryong magnanakaw. Yung mga ordinaryong magnanakaw, isang pakete ng sigarilyo lang po ang ninakaw o isang cellphone po, kulong kagad, no? Mag-snatch ka dyan ng cellphone at mahuli ka, kulong ka kagad, bugbog ka pa sa loob ng bilangguan. Kaya this is really a sad day. Napakalungkot po ito na araw para po sa milyong-milyong mga Pilipino na naniniwala na sana na doon na tayo papunta sa totoong pagbago, sa totoong pagpatibay, no, pagpalakas ng tinatawag na democratic institutions. So we have to accept it. The impeachment complaint, dismiss po yan. Dismiss. No? Hindi natin yung katapusan na pagsabi dyan ng chairman na si Congressman Vicente Ching Veloso. No? At sana po ay makabigay ito ng malaking aral sa ating lahat na hindi po madali yung pagsisikap ni Pangulong Duterte na i-reforma, no? Baguhin yung ating gobyerno, yung pakikaway niya sa korupsyon ay hindi po kasing dali. Kaya kailangan po ipatuloy, no? This should now reinforce yung ating pong damdamin. Kaya isulong po natin, ipagpatuloy po natin ito. Because we cannot allow na meron na pong tayong mga nagawang mga hakbang, no? Malayo na po ang narating natin kahit na marami pa rin na problema, pero huwag natin pong payagan na maurong muli kapag po itong mga dilawan at mga pulahan ay makabalik po sa pwesto gamit po ang pera ng mga oligarko. This is now about the people, the Filipino people, you and me, na asserting, no? Dapat po isinisigaw na natin ang totoong katarungan. We should shout for true justice. We cannot, I am sorry to say, no, nakakalungkot po, hindi po natin maaangkin ang totoong katarungan, ang totoong hustisya sa ganito po mga tao na nandyan po sa ating Senado at sa ating House of Representatives. So, I mourn this moment. Nakikiramay din po ako sa ating lahat, no? Sa ganito pong pangyari na pinabagsak agad, no? Hindi man lang binigyan ng pagkakataon na madinig itong mga akusasyon laban kay Justice Leonen. Sabi ni Tong, may bukas pa, no? Bawal po ang pangalawang impeachment kasi dinismiss . Kung ibinalik sana sa Secretary General ay maaari pa pong itong i-amendar. Kaya lang wala na po, dismiss no? 197, maraming pagkukulang. Totoo po, no? Sabi ni Conrado Dicos, delikado po sila makakabalik, no? Okay. Rochelle Colardo, they call themselves honorable. What a shame, no? Okay. Kampihan nangyari kahit labag sa batas, ang boses ng taong bayan ay hindi na sila ang representatives. Kaya because ulitin mo lang po, yung dahilan po dito, yung rules. Yung mga patakaran nila, at ito pong rules ay sila rin po yung gumagawa niyan. Kaya sila po ay talagang iginuhit nila yan para mahirap na mapanagot yung mga opisyal na mga tiwali po, no? Lalo na po na hindi sinusunod at binabaliwala ang taong bayan at ang saligang batas. Very sad. Nakakalungkot. But the fight is not over. Hindi pa po tapos. At ang sunod natin na pinakamalaking laban ay ang eleksyon, which is now less than 1 year, no? 11 months and a half na lang, no? Ang hihintay natin at makakapasiguro tayo na maipatuloy, no? ang ganito pong klaseng gobyerno ni Pangulong Duterte. At sana po sa susunod na eleksyon ay matutunan tayo na kailangan bigyan si Pangulong Duterte ng overwhelming majority both in the Senate and in the House of Representatives. Napakahirap po, kahit nga si Leonenin kaya niyang i-delay o i-block, no? Kaya niyang harangan yung mga pagsisikap ni Pangulong Duterte kahit na halatang-halata naman sa lahat na napakarami niyang katiwalian, lalo na po sa pagdating po sa corruption. It is a sad day, pero wala tayong magawa. Tanggapin na lang natin at we should vow, dapat po pangakuan natin ang ating sarili na hindi ito natin papayagan na magtatagumpay ang ganito pong mga tao na sila po ang maghahari sa ating lipunan at sila po ang didikta kung saan tayo patutungo. Ako muli si Manuel Boy Mejorada. Magandang tanghali po sa inyong lahat.